frankly, was the talking point for Scalia all the way up on through, and it was what prevailed in the Dobbs opinion too, which is this is a matter for the people. Mm-hmm. Then you have to let the people vote, and you have to let them be represented in a way that reflects majority will. You have to. Otherwise, you're further rigging the system for your own preferences.
Welcome to Law and Chaos. Today, we'll be discussing the Supreme Court with veteran legal reporter Mike Sachs, because it's a 6-3 world and we're all just living in it. Chief Justice John Roberts is finally in a position to enact every horrible anti-democratic policy conservatives ever wanted, but he finds himself constantly outflanked by the wingnuts, particularly on the Fifth Circuit, who care less about the legitimacy of the court and more about destroying democracy and civil liberties today. Meanwhile, in Florida, Judge Cannon is back on her bullshit. We have got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and in a minute we'll sit down with my buddy Mike Sachs to talk all things Roberts Court. But first, I want to catch you up on some of the crazy stuff going down in Fort Pierce, Florida in Trump's stolen documents case. By now, we've all heard of Judge Eileen Cannon. She's the living avatar of bad Trump judges. She's the one who made that atrocious ruling in 2022, allowing Trump to challenge the judicially authorized search warrant, and she got whacked down hard by the conservatives on the 11th Circuit. Ever since this case got assigned to her, we've been waiting for her to screw it up, and credit to our buddy Mitchell Epner, who suggested from the beginning that she's going to wait for the jury to be impaneled when jeopardy attaches, and then she's going to do something completely crazy, at which point it will be too late to appeal, because she sort of tipped her hand on that one this week. So what happened was that on March 18, Judge Cannon ordered Trump and the special counsel to write jury instructions, sort of draft instructions, for two competing scenarios, both of which appear to contemplate blessing Trump's declassification by theft theory of the case. So, okay, here's the first scenario. She's asking for them to draft jury instructions kind of under this premise. She says, in a prosecution of a former president for allegedly retaining documents in violation of 18 U.S.C. 793E, that's the Espionage Act, a jury is permitted to examine a record retained by a former president in his or her personal possession at the end of his or her presidency and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is personal or presidential using the definitions set forth in the PRA. That's the Presidential Records Act. So, okay, let's break it down for a sec. Trump is charged under the Espionage Act with unlawful possession of national defense information. Many of the documents he swiped are classified. Some of them are highly classified. As we've discussed on the show with Cal McClanahan, our buddy national security counselors, classified evidence is governed by the Classified Information Procedures Act, and it does not necessarily get shown to the jurors, right? Because, if you steal the military plans to invade something or the layout of the nuclear reactor, you can't show that to the jurors. And that's what the Classified Information Procedures Act says. So right there, Judge Cannon is saying the jurors will get to evaluate this evidence and make a finding of fact as to whether it's personal or a presidential record, and that's an apparent contravention of CIPA. But more importantly, Trump is not charged under the Presidential Records Act, which was passed in the 70s to stop Richard Nixon from destroying all the evidence from Watergate. He's charged, as we said, under the Espionage Act, a criminal statute which cannot be subordinated to the PRA. And even if Trump did have personal documents, if they related to the national defense, he still couldn't store them in his bathroom or the pool locker at Mar-a-Lago. That's ridiculous. Then we come to the second, draft instruction, which is actually much worse. She says, a president has sole authority under the PRA to categorize records as personal or presidential during his or her presidency. Neither a court nor a jury is permitted to make or review such a categorization decision. Although there is no formal means in the PRA by which a president is to make that categorization, an outgoing president's decision to exclude what he or she considers to be personal records from presidential records transmitted to the National Archives and Records Administration constitutes a president's categorization of those records as personal under the PRA. Okay, that right there is conceding Trump's wacko declassification by theft argument, right? So Trump's lawyers have said pocketing the stuff and walking out with it magically declassified all the documents and converted them to personal records. So she's saying if he didn't hand that stuff over to the National Archives, he de facto was calling it a personal record. But remember, he's not charged under the PRA. He's charged under the Espionage Act. So taking this crazy argument as the basis of the jury instruction would functionally be telling the jury to acquit, right? If Trump could actually make stuff into personal records by stealing it, then what is the point of the PRA? Nixon could have just walked out with the Watergate evidence and no one could stop him. That cannot be right. It's clearly erroneous. So Tuesday was the deadline for the parties to respond to this, request to come up with jury instructions with my, fakakta scenarios in mind. And Special Counsel Jack Smith came out swinging here. He says, the court has issued an order directing the parties to file preliminary proposed jury instructions and verdict forms for counts 1 through 32 of the superseding indictment, with a specific requirement that the parties, quote, engage with two competing scenarios and offer alternative draft text that assumes each scenario to be a correct formulation of the law to be issued to the jury. Both scenarios rest on an unstated and fundamentally flawed legal premise, namely that the PRA, and in particular its distinction between personal and presidential records, determines whether a former president is authorized under the Espionage Act to possess highly classified documents and store them in an unsecure facility despite contrary rules in Executive Order 13526, which governs the possession and storage of classified information. That legal premise is wrong, and a jury instruction for Section 793 that reflects that premise would distort the trial. The PRA's distinction between personal and presidential records has no bearing on whether a former president's possession of documents containing national defense information is authorized under the Espionage Act, and the PRA should play no role in the jury instruction on the elements of Section 793. Which is, you don't have to be a lawyer to realize that's pretty strong language. He's saying, look, Judge Eileen Cannon, you have gotten this law very wrong, and, you are bad and you should feel bad. Which, okay, I agree. The document continued in that vein. The prosecutor said it was vitally important for the judge to say immediately if she's going to go with this insane jury instruction so that the government will have the, quote, opportunity to consider appellate review well before jeopardy attaches, which, right, like we said, once you swear in the jury, it's a done deal. A bad jury instruction cannot be undone and it cannot be appealed. So if Judge Cannon wants to bone this case with no recourse, she can give that crazy jury instruction and be done with it because that's an instruction to acquit and there is nothing the special counsel can do about it. So Jack Smith has now asked her to rule on the PRA issue immediately to avoid that trap. He says the question of whether the PRA has an impact on the element of unauthorized possession under Section 793E does not turn on any evidentiary issue, and it cannot be deferred. It is purely a question of law that must be decided promptly. If the court were to defer a decision on that fundamental legal question, it would inject substantial delay into the trial and, worse, prevent the government from seeking review before jeopardy attaches, which, let's be clear, jeopardy attaches means you can't be retried, and that is what she is setting up to happen here. So the special counsel is very unsubtly threatening to go to the 11th Circuit immediately and get this overturned. And look, in case Judge Cannon managed to miss it, he reminded her that the last time she made him take it up with her manager, she got humiliated. So he quotes the 11th Circuit's order from 2022, not telling Judge Cannon that she had made a fool of herself and gotten the law completely wrong. But he quotes a particular passage because the appeals panel said at the time, quote, Trump does not have a possessory interest in the documents at issue, so he does not suffer a cognizable harm if the United States reviews documents he neither owns nor has a personal interest in, right? Because Trump was trying to claw those documents back before he was charged. And he said, these are my personal things, or he made a lot of very strange claims. And the 11th Circuit said, no, these are not your personal documents. They are government documents. They are not yours. So you don't get to kind of argue about them at this stage. The government, in its brief, also spent a lot of time pointing out all the times Trump and his lawyers conceded that these were absolutely, definitely presidential records, right? Trump spent months trying to assert executive privilege over them, which would mean they were definitionally not personal records. That was the last time he was before Judge Cannon, and he said, I assert executive privilege, and so prosecutors can't look at this to see what I stole. That didn't work, but fundamentally, if you're trying to assert executive privilege over something, you're saying this is a document which belongs to the executive branch and it's not your personal thing. His lawyers also called these presidential records in communications with the government. It was only when this weirdo named Tom Fitton, who runs this conservative activist group, Judicial Watch, started whispering nonsense in Trump's ear that he changed his tune. Because Tom Fitton, we've talked about it, we're not going to go into it today, but he talks about this thing called the Sox case, which was a Clinton-era case where Judicial Watch sued to try and force the government to go and seize tapes which Clinton had made with his biographer. And the court said, I can't order NARA, the National Archives, to go get those. From which Judicial Watch, or Tom Fitton at least, has decided that that means that it's unreviewable. If the outgoing president says, this is my personal record, he could say that about the entire nuclear archives. He could just declare them personal records and pocket them and, stick them in the pool locker, and there's nothing any court can do about it, which just can't be right. So, as the government points out, Fitton is not a lawyer. And look, Trump never made that claim before. Trump has said, I declassified these. These were always personal records. But he didn't ever say that before. He didn't say that until he started talking to Tom Fitton. Like, when those documents were subpoenaed in 2022, he didn't say, I moved to quash this subpoena because these are personal records. He just said, I don't have them. He lied about them. He never made this argument about them being personal records. He just hid them. So, be for freaking real, dude. So the government was ordered to craft jury instructions to comply with this clearly erroneous standard Judge Cannon set out. And remember, on Law and Chaos, Mitchell Epner did suggest that the government might simply refuse to do it, kind of invite the court to hold them in contempt, and thus manufacture an appealable issue, right? They could appeal the contempt order. That's not what they did. Instead, they wrote the instruction, the jury instruction as ordered, but it's super snide. It's hilarious. It's a big F you. So this is what they are saying, like, okay, Judge Cannon, you want us to do this. Here's what we think you should say. Even if an individual holds a security clearance and has a need to know classified information, the individual's possession of the classified information is unauthorized if the individual removes the classified information from a secure facility or possesses the information outside of a secure facility. I instruct you, however, that as to a former president, even if he lacks a security clearance, lacks a need to know classified information, and stores information outside a secure facility, he is authorized to do so if the classified information is contained within a, quote, personal record, as that term is defined by the Presidential Records Act, a statute that establishes the public ownership of presidential records and ensures the preservation of presidential records for public access after the termination of a president's term in office. So, basically, they were saying, yeah, you want to stand up there and say, all kinds of contradictory things and make yourself look like a jackass. No. Trump also responded. I'm not going to spend a lot of time on his response because basically he just regurgitated stuff that he'd said in his prior motion to dismiss under the PRA, which is, that's basically the second jury instruction, right? The declassification by theft, whatever. So today, Judge Cannon issued a ruling. Let me back up and say that there's been a lot of reporting from David Latt at his Substack Original Jurisdiction about turmoil in Judge Cannon's chambers with law clerks quitting and the jurist kind of cracking under the pressure. Basically, they say that she's not handling it well. And that definitely showed in her response today. So what she was responding to was Trump's motion to dismiss under the PRA, which, it's one of many, many motions he's flung out. He's filed motions to dismiss, like 6 different motions to dismiss, and she hasn't had the bandwidth or desire to deal with them. And, partly I think that's because she's trying to slow this down, and partly I think it's because she's so out of her depth and kind of losing it. So she did deny the motion to dismiss under the PRA, and she did it in one page. She's been sitting on this thing for months, right? She has one page where she's like, nah, I don't think so. And then on the second page, she got very huffy and she yelled at the special counsel for demanding that she rule on the jury instruction. Never mind that she's the one who brought the jury instruction up. Like, lady, no one was talking about this, but you're the one that ordered them to come up with this jury instruction under these, bizarre, erroneous legal standards. So she says, separately, to the extent the special counsel demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust. She's got no citation for that, of course. The court's order soliciting preliminary draft instructions on certain counts should not be misconstrued as declaring a final definition on any essential element or asserted defense in this case, nor should it be interpreted as anything other than what it was, a genuine attempt in the context of the upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. Okay, it's not a complex case of first impression. There are plenty of precedential 793E Espionage Act cases on the books. There was one that was I think last month, there was a conviction under this act. It is not a case of first impression. I mean, Trump is just full of shit. And she's the one that brought this up and asked them to, come up with these completely crazy jury instructions. So after that, she dared the government to go to the 11th Circuit, which, okay, I mean, yes. Look, she said, I'm not going to rule right now. And seeking a writ of mandamus is a heavy, heavy lift. I'm not going to go into the details, but it's not something which courts don't want to do. She already got knocked down before, but, there's no looming trial date here. And the judge, it's not like she's been sitting on this for so long that it's abusive. She said, I will rule when the time is right. And that's not clearly erroneous. So, all right, it's a problem. It's going to be a tough slog. It's put Special Counsel Jack Smith in a tough position. But I think, from my perspective, it was good that he came out swinging on this one because this just can't stand. If she's allowed to give this jury instruction, it'll ruin the case. Okay, there was also great hilarity in New York today with respect to Trump's bond in the civil fraud trial. I will break that down for you on Monday because we are having a Trump-focused show. But trust me, that was funny. Okay, so if you are a Patreon at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, you get the show ad-free every time. And if not, maybe today is the day you would like to become a subscriber. We will see you all back here in a minute. We are just going to pay some bills, and we will get to our interview with Mike Sachs. And with me today is Mike Sachs, a longtime legal journalist at various outlets such as the Huffington Post, where he was the Supreme Court correspondent, and later at Fox in New York. He is now the senior advisor at Court Accountability, a nonpartisan 501c3 research and advocacy organization committed to restoring the integrity of our broken judiciary. Mike Sachs, thank you so much for being here.
Hey, Liz.
How are you?
All right. I'm really happy to see you, hear your voice, although people won't be seeing us here. We're wearing our glasses and not looking particularly camera presentable.
I look amazing, and I will not put up with this
for myself.
Slander, vile slander. Okay, so tell me about your new job.
Yeah, it's a pretty great organization. As you mentioned, it's called Court Accountability, and our focus is to ensure that the general public and activist groups and people on the Hill and anyone who has any interest and stake in our judiciary, which is everyone in this country, understands that we are in a pretty anti-democratic moment that has delivered us a judiciary that's largely been bought and paid for by certain moneyed interests that have a shared project in making sure that only their way goes moving forward, whether that's through the judiciary and the juristocracy they've erected to smack down any democratically motivated law or policy emerging from, say, a White House or a Congress in the other side's hands, or whether it's through winning via electoral college, because come on, it won't win for popular vote, the presidency, or if they lose the electoral college, through outright subversion, like we saw attempted in 2020, an attempt then to put into place an administrative infrastructure that will again serve against the popular will and serve to lock in a minoritarian way, the policy preferences of this faction. So court accountability is raison d'etre, if you will, is to put all of that above board, make sure people see that and know the connections between members of our Supreme Court, certainly members of the lower court judiciary, and those serving in various activist and advocacy roles emerging out of, say, Leonard Leo's financial network, the Federal
Leonard
Society's.
Leo. Yeah.
Uh,
Let's come back to him in a second because you used a word that I don't hear a lot. I don't know whether it's a neologism or whatever. You used the word juristocracy. What do you mean by juristocracy?
Rule by judges. It's one of my favorite words. It's been used it hasn't been used as much over the years, but in the past 5 or so years, you've been seeing it used a lot more. And really, it's simply the transfer of power from the people to unelected judges. Now, of course, that's something you would hear a lot coming out of conservative side activism and politics. I think you and I grew up with every Judiciary Committee hearing for any Supreme Court justice saying, with the Republicans saying, "Are you for or against judicial activism? Do you believe in legislating from the bench?"
Right.
And that underneath all of that, of course, was Roe versus Wade, and to an extent, some Warren Court criminal justice opinions. But now we have a court that, on the conservative side, is aggressively and actively doing exactly the same.
Right.
But rather than doing those things to vindicate and buttress American democracy, as you saw with, say, the Warren Court during the reapportionment cases and what have you, you have a court that's actively working to thwart American democracy and put a thumb on the scales for its own partisan allies and its own political allies, and to perpetuate its own power despite what we the people want to say or do.
Right. I mean, I think we've seen so many examples, and we're going to see so many more. You and I talked about this off the air, of the court kind of arrogating power to itself and taking away legal protections, which we've all enjoyed, and creating its own law. So, like, as you said, when we were growing up, the court, conservatives particularly, complained about activist judges because they said these judges were kind of changing the law from the bench. And they, as you said, they hated Roe v. Wade. They thought it was judicially constructed law and that it was kind of finding a right by implication that didn't exist in law or in the Constitution. And now the shoe is on the other foot, and they have the power. And actually, turns out they really do like those activist judges quite a lot.
At least on their own. And this is what you have with originalism, what you have with any kind of isms that emerged on the right to act against the Warren and early Burger Court liberal precedents. But they're ostensibly neutral methodologies that were incredibly successful public relations campaigns and messaging campaigns that served no more as a fig leaf to vindicate these conservative policy preferences. Every once in a while, you'll have, Scalia with flag burning or Justice Gorsuch with tribal rights. Mm-hmm. And you can kind of go justice by justice, except for perhaps Justice Alito, and find the beard, find the one position that they've adopted to say, look, this is a neutral position. I don't always find conservative results. But on the things that truly matter to the movement, it doesn't matter whether one subscribes to originalism or pragmatism or results orientation or just being a rank partisan like Alito. So long as you find your way to the right result, then all is forgiven. So you saw Senator Hawley, for instance, turning against originalism when Gorsuch, the court's what should be the purist for FedSoc test tube baby originalist textualist, came out to read Title VII of the Civil Rights Act to put LGBT underneath sex discrimination in the Bostock case. And he did so in a very textualist manner. And you saw movement conservatives saying, if this is textualism, then we're not having any part of this. That took the mask off a bit and showed once we have the power, we will use it for our end results. It doesn't happen every single time. Sometimes certain things get in the way, or certain cleavages between and among members of the right, those emerge. And you're seeing some of this term too, which we can talk about. With the abortion pill case and standing. You see it with the content moderation cases and the traditional vision of the First Amendment protecting from government encroachment versus saying that content moderators, private actors, are acting quasi-governmentally, so they are suppressing people's First Amendment rights, even though they're not government. And these are divisions you're seeing now within the conservative movement as they're trying to figure out this sort of post-counter-revolutionary moment. They've overturned Roe. They've gotten rid of affirmative action. They've expanded gun rights. They're about to overturn Chevron. What comes after all these things is that hasn't yet been settled on that movement.
Right.
But what we're seeing though is what we've just seen is the conclusion of a 50-year project.
Right.
To effectuate a counter-revolution against the greatest hits, or the worst hits, if you will, from their perspective, of the Warren and early Berger years. Now we're seeing where the Leo network's interests are looking and how they butt up against perhaps those who took in semi-good faith the movement against the Warren Court. So you're going to see the attempt to pretty much theocratize our government. You're going to see attempts to fully effectuate minority control in ways that I think will make certain elements of the conservative legal movement and political movement even maybe uncomfortable, but make other aspects, the vanguard, the younger elements of that movement, quite comfortable and ready to seize that power.
Yeah, I think you and I have talked about this, that you can see this kind of tension between Chief Justice Roberts and, Justice Alito, and that they do kind of represent two different wings of conservatism. I mean, when he was appointed, none of us was like, oh, Chief Justice Roberts, he'll be like kind of a middle of the road median justice. We thought he would be pretty substantially to the right, and, we were wrong. Or maybe we weren't wrong, but the ground moved under us, and now he is closer to the median.
That's exactly right, because things shifted even more to the right under him. And, my working theory of Roberts is that if he hadn't been Chief Justice, if he had been Justice O'Connor's replacement, as was originally planned before Rehnquist up and died, that Roberts would be very similar to Alito in how he rules and how he votes. Because he wouldn't have these institutional concerns of a court with his name slapped in front of it. He wouldn't see himself as a steward of the court. He'd be just another associate justice. Now, I could be wrong, and we could have been seeing this entire time his general disposition. What's been fascinating for me to watch is Alito, because Alito and Roberts in their early years, between 2006 and 2012, seemed to share the same project. They both wanted to go in the right direction, which was hard right. Mm-hmm. And they both tag teamed these sort of 1 or 2 or 3 step jurisprudence where they'd take a case and they'd vote, to take a big bite out of something, but not go all the way, and then wait for the second case to take the next bite. You saw it with campaign finance, you saw it with voting rights, you saw it a little bit with Establishment Clause stuff, leaving Thomas and Scalia to say, man, this is faux judicial restraint. We know where you guys are going. You're just trying to placate the political classes, whereas we're the real ones. But then you had this moment with the Obamacare decision in 2012, where Roberts switched his vote, upheld the individual mandate, and we can talk about how that ruling still pushed the law deeply to the right, yes. which is Roberts' specialty. Anytime he sides with the left, he still manages to push the law to the right. That's what he's done all along. And that switched vote had turned Alito haywire, and from that moment he was mask off, and he's served as a rank partisan ever since.
Oh, interesting.
In ways where, since Scalia's death, he's more fully joined hands with Thomas, and they have their own reasons for where they go and why they go there, but they are both now the very hard right of the court. Thomas, you can argue, has some intellectual mooring behind everything he has done and everything he says. And it might be shifting. It might be a fig leaf. It might be any of those things. Mm-hmm. But he at least tries to explicate his own decision-making based on, what if the latest research and is coming out of law schools that are funded by Leonard Leo. Meanwhile, Alito just says, where does the Republican Party want to go right now? Okay, that's where I'm going to push it. Mm-hmm. Rank partisan.
Right. I mean, he's totally disregarded not only stare decisis, but things like standing, right? He's, like he said earlier last week in the Mifa Pristone oral argument, where he said, well, if you don't have standing, who does have standing? Well, Alito, old Alito would never have said there has to be somebody with standing. They were never in the business of throwing open the courthouse doors to all comers. And now he would like very much for somebody to be able to challenge the FDA.
Yeah, and what's wild about that is that Alito himself, in a liberal-facing major standing case from about a decade ago, ACLU versus Clapper, or Clapper versus ACLU, which emerged back when we were worried about privacy and the NSA spying and things like that. he wrote the 5-4 opinion saying, no, get out of here. You don't have standing, ACLU. You can't bring that kind of thing. And by its own language, he addressed this idea of, sometimes someone doesn't have standing. You just can't do it. Sometimes there's just no avenue forward. So I'm actually not entirely convinced that I think he still might be a vote for no standing in the abortion pill case. I could be very wrong about that, but I think that he was more expressing a rage at the Biden administration for jerry-rigging this argument to shut anyone out. And he wanted to send a message saying, I see you, and I'm going to get you next time.
And the next time is there, right? Because Judge Kaczmarek, the trial judge, has already kind of teed up the Republican attorneys general from all of these states to challenge it. So he knows. I mean, I agree with you that there is certainly a possibility that Alito will kind of show a modicum of consistency and toss this mifepristone case on standing because he knows that it'll be back, right? It's going to go back to Judge Kaczmarek. And you know what? I would like to talk, because you and I have talked off air about the tension between what Chief Justice Roberts wants to do, how he would like his legacy, for lack of a better word. And by legacy, I agree with you. I think he sees the court as being broadly delegitimized under his watch from a bunch of things, including, the very public ethical lapses or, by particularly Justice Thomas, and also these kind of wildly extra-legal decisions which are coming out of the Fifth Circuit.
Yeah. Right now, I think the story for this specific Supreme Court term is we're not those guys. Like, those guys are crazy.
Right. Those guys on the Fifth Circuit.
Yeah, right. We're good stewards of law in this country.
Do you want to break down how that's working out, on the ground?
Yeah, we can do that. So this term, and the past couple terms, there are a bunch of cases from the Fifth Circuit, but probably the most ridiculous ones this term so far are the Second Amendment case, Rahimi, which is a challenge to the federal law disarming people under protective orders for domestic abuse, domestic violence. And the Fifth Circuit, in its wisdom, said, there was no history or tradition of disarming people under protective orders of domestic abuse and domestic violence back in 1791. So sorry, that law's got to go. They were following the dictates of the 6-3 decision from a couple of years ago in Bruin, which expanded the Second Amendment's reach to carrying firearms outside of the home. Mm-hmm. And the court, in doing so, leveled a whole decade's worth of tests that the lower courts had been developing on how to decide whether something is or isn't, protected by the Second Amendment, and instead adopted the sweeping history and tradition interpretation of whether something is constitutional. There's no interest balancing. It's just, is there a historical precedent for this regulation that we can ascribe to either the founding era at 1791 when the Second Amendment was ratified, or the second founding in 1868 when the 14th Amendment was ratified and made the Second Amendment ostensibly applicable to the states. And that test was articulated by then Judge Brett Kavanaugh on the D.C. Circuit when he was voting to overturn D.C.'s assault weapons ban. So get ready for that in a year or two. But by the time that got to the court and the court made that its test, I don't think it had in mind it didn't have in mind bans for domestic abusers.
Right. It
had in mind assault weapons bans. It had in mind sensitive, like where you can take guns in sensitive places. It had in mind all sorts of regulations that they probably want to get rid of, but they didn't have in mind this terrible fact pattern. So right now we're seeing kind of a cleanup on aisle originalism, with the Supreme Court saying they're going to start saying, "Oh no, we didn't mean it to go that far." And the Fifth Circuit, being this court that wants to go that far in everything, did go that far here. There's then the abortion pill case, right, which the Fifth Circuit did its attempt to clean up on aisle of Judge Kaczmarek.
Right. I mean, let me just interrupt you for a second and kind of break that down, because you've mentioned Leonard Leo.
Yeah.
And so Leonard Leo is kind of this architect. He's the Mr. Moneybags. He's financed and kind of managed this 50-year project. He hasn't been doing it for 50 years, but he's been doing the last, say, 3 decades of taking over the judiciary and converting it to like a tool for conservatives to enact their preferred policy, despite the fact that their preferred policy is not really the preferred policy in the main of Americans as a whole. We would, like to have abortion rights. We would like to have health care. We would like to have ungerrymandered districts. If you ask Americans, they overwhelmingly want those things. But we cannot have them thanks to Leonard Leo and also thanks to Mitch McConnell. So on the ground, what we're talking about here is these like single member districts in places like Amarillo, Texas, where if you file there, you will get this one judge who was appointed by this kind of, who was installed there by the Leonard Leo network in concert with, Mitch McConnell. So that's how the Mifepristone decision was teed up. That's how the net choice cases were teed up. They were filed where they were pretty clearly going to get Judge Terry Doughty. We've talked about it on the show a bunch as well. We've talked about Elon Musk would like very much to be before Judge Reed O'Connor in Texas. So he files all of his cases against Media Matters and the Center for Countering Digital Hate. He files all of his cases in this very particular place in Brownsville, Texas, because that's the judge that he wants. But in the Fifth Circuit, what you're talking about is cases that are queued up because they get filed in Amarillo, and then they get fed to the Fifth Circuit, which is, seated with all of these horrendous judges, the worst being James Ho. And then they do something completely batshit crazy and send it onto the Supreme Court and say, well, if you make this 10% less crazy, then, it'll still be crazy, but you'll have changed the law drastically in ways that Americans don't like.
Mm-hmm. Yeah. And, Ho in the abortion pill case was, I believe, entirely aligned with Kaczmarek when it got to him. But the rest of the court wanted to narrow Kaczmarek's opinion to make it a little more palatable to the Supreme Court. But they still bought the standing issue to let the plaintiffs into court in the first place. And this Supreme Court, I think, even if it might on the substance, there might be 5 votes to affirm the Fifth Circuit's narrowing of Kaczmarek's crazy opinion. I don't think there's going to be 5 votes to find standing for them. But that's the story of this court. That there was a few years ago an attempt from out of Reed O'Connor's district, an attempt to overturn Obamacare when the Republicans failed to do so when they had unified control of Congress and the White House. And O'Connor was all too willing to engage that and say, yes, Obamacare gone through this weird Rube Goldberg style argument you put to me. And by the time that got to the Supreme Court said, no standing. So you still see that a little bit when the Supreme Court's saying, I will do anything for whatever, but I won't do that. The Fifth Circuit and the Trump vanguard judges and some holdovers like Reed O'Connor of the George W. Bush appointee vintage will do that for their for their agenda. But this Supreme Court, with the justices who were on it, were assembled for a very specific reason, which was to settle all the scores that were built up over the last 50 years that repeated Republican appointees failed to do. And you mentioned Leo sort of being the architect for the last 30 or so years. You can track that back to Planned Parenthood versus Casey in 1992, when this court, where there was only one Democrat on the court, and he was the anti-Roe Democrat going back to the very beginning of Roe versus Wade, this court with 8 Republicans still managed to be a 5-4 decision to uphold the core holding of Roe versus Wade and the right to abortion. And that emerging out of that became this talking point: no more suitors.
You mean Justice David Souter?
Justice David Souter, who was, who should have been, after all these failed attempts, the 5th vote to overturn Roe versus Wade. And he, with Justice O'Connor, who was supposed to be the 5th vote back in 1981 to overturn Roe versus Wade, and then Justice Kennedy, who was supposed to be the 5th vote in 1989 to overturn Roe versus Wade, or 88, whenever he was put in. Souter then did the same thing. And it caused it created this rallying cry from which Leo emerged, from which Gorsuch emerged, from which Kavanaugh emerged, and from which Barrett emerged. And Roberts and Alito were certainly on board with that to begin with in the first place, but Roberts, given his institutional position in the court, wanted to kill Roe in 2 sword strikes as opposed to 1.
Right.
So what we had was a court constructed to settle these old scores. And it was constructed through vast amounts of money, vast amounts of coordination, ultimately till it found a champion in the Trump administration, and then a willing participant to usher it in with Kennedy's retirement, and an unwilling participant to clinch it with Justice Ginsburg's death.
Right. And
now it's a matter of looking at where that network, where that money, where that coordination is looking to go next. Where these, the millions upon millions of dollars from the $1.6 billion donation that Leo got a couple of years ago from a Chicago-based industrialist, where they're going to be placing that money. And right now, that money is still being placed in litigation. That's getting before Judge Kaczmarek and going to the Fifth Circuit, and all the public interest, if you will, organizations that bring these cases, whether they're anti-abortion cases or whether they're Christian nationalist cases, or whether they're anti-agency and administrative state cases, or whether they're anti-affirmative action cases. They're all still coming up. They're all still hitting the districts where they believe they'll get the best look, to then go to the circuits where they believe they'll get the best look. And if they don't get a good look there, there's still a sense that there'll be a happy ending at the Supreme Court. This is something that we have to keep our eye on. We have to understand. We have to see it's not a crazy bored, Charlie Day from Always Sunny or Claire Danes' character in Homeland, mapping out all the connections on.
Right. It's not a Pepe Sylvia string board, right? This is real. This is a real thing.
This is thing. If you follow the money, you see where all the money has gone and where it's going. And it's an ecosystem that's dedicated to locking in minoritarian power, either through the courts or through an electoral college win or a straight up election subversion through the administrative state they so claim to hate.
So can you talk to me a little bit about, some people kind of think of the court as a 3-3-3 court as opposed to a 6-3 court. And can you give me your take on that? I mean, Obviously the three liberals would be Justices, Sotomayor, Kagan, and Jackson. But there do seem to be these divisions among the conservatives.
Let me just say one aside real quick. You can tell a real one when you're talking to one when they list the justices in seniority, which you just did. Like, it's something, even if one doesn't like the court, even if those of us in that world will still, when listing the justices, list them in seniority rank, because we are still lawyers. We are still hierarchical, unfortunately.
Yeah.
And we still will make at least some due recognition of the traditions and mores behind this stupid institution that we all still are obsessed with.
Yeah.
But so anyway, so you have those three. And then, you have the other 6 Republican appointees. And there was this debate a few years ago, whether there's this 3-3-3 set up with Gorsuch, Alito, and Thomas, which I did not. That was in reverse seniority order right there, and on one, and then Roberts, Kavanaugh, and Barrett. I did that in seniority in the middle.
Yeah.
But then, of course, what is the middle, which you mentioned before? The window is so moved since Roberts was first joined the court that somehow these hard right, rock-ribbed conservatives are considered in the middle, and. The general theory, the general pattern I see is, again, on matters that were key to the counter-revolution, they'll stick together.
Yeah.
Except for Dobbs, where Roberts got off the bus. But again, it's not because he didn't want to go where the bus was going. It's he was pissed that he wasn't driving it anymore.
And because it was so egregious, right? It had been a part of this whole thing where they started the bounties. I mean, this was out of the Fifth Circuit. This was once again a Fifth Circuit special where they cooked up something so crazy and so extra legal that it made him feel icky. It made Chief Justice Roberts feel icky about so very obviously throwing away all of his prior, all of the standing issues and all of the things that we all believe about, settled law. And
it was also that you're talking about SB 8. It was unconstitutional at the time, even though they all knew that they were going to, at the end of the term, overturn Roe versus Wade. So, it wouldn't have been unconstitutional at the end of the term. It was unconstitutional. But so there was this debate over, how they divide. And we've started to see in the past couple of years that there is this very real, not altogether consistent, but very real division between it's porous. You'll almost always have Thomas and Alito, and sometimes with Gorsuch, and sometimes with Kavanaugh, or sometimes with Barrett. But there's that hardcore 2 with the soft core 3, and then sometimes 4 and 5. And then again on the things that are core to the movement, 6. You'll see that with Loper Bright and Relentless, with overturning Chevron this term, or gutting Chevron, whatever they're going to do. That'll be 6.
Right, right. For the non-lawyers listening, what Mike's talking about is that on things which are super serious conservative priorities, particularly when they have to do with corporate rights, or to be really clear, making America a better place for corporations to exist, right? So those are all going to be 6-3 decisions because that is core to the Republican political project. And it's one of the things which ensures that they get adequately funded, right? You're not going to get buy-in from all of the billionaires that you need to pay for all your pet projects if you start acting, like a little pinko. But but when there are things which are sort of embarrassingly big swings, like the Dobbs decision, then you will have some sort of peel off. And particularly, the more embarrassing, the more you will have conservative justices peel off. And so you will just have the two, i.e., Thomas and Alito, on one side. But I mean, we've talked about this, you and I, about Kavanaugh being the median justice, which is an extremely uncomfortable place for me as a liberal and as a woman, because he is so repellent. But we do indeed have to rely on him in several decisions, like the net choice decision, where he was so deeply skeptical of the conservatives' position. That was we talked about it on the show with Tech Freedom's Corbin Barthold, that Kavanaugh was like, hey, the First Amendment, it actually means something. Stop screwing around here. Why are we even doing this?
Yeah, Kavanaugh is not going to distort longtime conservative legal principles in service of a rank partisan end like Justice Alito will. He just won't. It's not who he is. And each and every one of the justices, all 9, have their own personalities and politics and preferences that go into their votes. And they might group them 6-3, but each of them has a reason behind it that's individual to his or her own position. Kavanaugh's read is, again, he's a no more suitors counter-revolutionary. And he wasn't going to blink before overturning Roe versus Wade. He wasn't. That people thought maybe he will, and there was scuttlebutt about Roberts trying to get him over. And Roberts wasn't in Dobbs. He didn't think that overturning Roe was laughable or egregious. He just thought it would hurt the Republican Party. He thought it would hurt the courts as an institution. Everything Roberts has ever done has been like saying, I know what's best for the Republican Party Republicans, and where you're going on this, that's going to hurt you. Please, just listen to me. I'm guiding you. We're going to be okay if you just stay with me.
Right. Or the census decision, when he was like, oh my God, if you guys could have just shut up about it, I could have let you rig this entire thing. And you were so egregiously open about your corruption that now I have to rule against you. Thanks a lot, assholes.
Yeah. And he would have ruled for them, but for a New York Times article that came out a month before actually taking the mask off and saying the entire project was in fact racist. So long as he had plausible deniability, he probably would have cited for the census citizenship question. But he lost that,
100%.
And therefore he moved his vote. And you see with Dobbs, the Dobbs aftermath, Alito's line, women are not without their political and electoral power, which Biden said during the State of the Union, that was true. And It was handed on a silver platter as a rallying cry for those who wanted to use their majority will to protect abortion rights. As we've now seen, it's become a hugely galvanizing thing that has hurt Republicans at the ballot box.
And Roberts was right. Roberts was like, can you guys just ixnay? Stop being so damn obvious about it. If you guys could just be cool for 5 seconds, we could get this shit done and not pay a massive political price.
But there were 5 justices to the right of him, and he lost that power. Last term, Roberts regained control a bit because they were responding to some of the more crazy stuff that then he was able to get all the other 5 with him. But this term is very much going to be, I think, the term of Kavanaugh. And that's because he's sort of straddling the rank hack versus the enduring conservative principle divide. And he often tries to have it both ways because, as you see in what's become a very a pattern with him, I call it the Kavanaugh concurrence. Anytime he swings right on a position that will upset liberals, he writes a concurrence saying, but please like me still, liberals. Please like me. I'm not a bad guy. Trust me.
Right.
And, his reputation before Christine Blasey Ford's testimony came out was very much that. He was the conservative on the D.C. circuit in D.C. who had effectively laundered his reputation as a rank partisan in Bush v. Gore and then in the Bush administration. Once he became a judge, he very much wanted to be the rock rib conservative judge that people could like, or the liberals in DC could like.
Right. He doesn't want to be Naomi Rao.
Yeah, no, or
Justin Walker.
We can talk about that in another episode. But Kavanaugh was like, you're not going to change my vote. You never will. And I'm going to start building, I'm going to start doing what Leonard Leo wants now from 2005 to 2019. I'm going to start undermining the administrative state. I'm going to start expanding gun rights. I'm going to, when an abortion case does come to me, I will wriggle out of it to preserve my own prospects of the Supreme Court. But his whole, I guess he did vote in, but he wriggled out of striking out Obamacare also. He found a technicality out of it instead of upholding on the merits. But his whole thing was, you can do business with me. Like we can get along. We'll be co-judges at the Shakespeare moot court trial, for a bunch of donors on the Georgetown cocktail party set, if that even exists anymore.
Right. Nobody's going to yell at you at the Bethesda Whole Foods if you're Justice Kavanaugh.
Yeah, people like he was well liked. He was the liberal he was the conservative that liberals could like, and he treasured that reputation. And he had to sacrifice that on the altar of his greater ambition for the Supreme Court in order to keep his nomination alive from President Trump. That snarling person you saw, who reaped the whirlwind, the Clintons and whatever that you heard when he had to come out and counter for delegations. That's not how he ever saw himself, and that's not how he's tried to be, that's not how he's been trying to depict himself once back on the bench and trying to rehabilitate what he once was, which he never will be able to do because people won't forgive him. But that hasn't stopped him from trying. And so in the Dobbs decision, he issued a concurrence saying, Constitution is value neutral. I'm not out for ending abortion nationwide. I'm not in that business. You can do what you want as long as you do it in the ballot box. And there's the right to travel, so I'm not going to uphold any attempts to block women from leaving Mississippi or now Florida or Alabama to get their abortion. Nope, I'm not going to get in that way. So please like me still. Mm-hmm. You saw it when he dissented in the Bostock case.
Right. He's like, I'm not a bigot. Yeah. I just, Constitution, I had to do it.
Well, he was saying this is not in the law. Like sexual orientation and gender identity wasn't contemplated by those who passed the civil right, the Title VII. It wasn't. Mm-hmm. Vote on it. Great. Awesome. If you vote on it, wonderful. And he does this sometimes when he swings left too. Like he'll apologize to the right, let them know like, I'm still one of you guys. Like, don't hate me. Yeah. I'm still one of you. So that kind of that guides Kavanaugh as he's finding his way forward. On voting rights, he left out a loaded gun last term on Section 2 of the Voting Rights Act, which is the only thing that really remains standing with teeth after the Supreme Court in 2013 gutted Section 5, which was the pre-clearance position that really prevented the havoc we've seen ever since in the state in the states from voter suppression and election interference. And Kavanaugh, surprise, sided with Roberts, which was a surprise, and the three liberals to rule that Alabama's racial gerrymander was in fact an illegal racial gerrymander. But Kavanaugh wrote a concurrence. This was his apology to the right, saying, "Hey, but guys, I think maybe Section 2 could be unconstitutional if it goes on for too long. So maybe start throwing me some more cases that say that Section 2 has outlived its utility and is actually in conflict with the Equal Protection Clause in helping out Black people."
Right.
And Alabama got the memo, and they tried again by reenacting the same maps, and they brought it right back to the court, and the court said no. Because Kavanaugh wasn't quite, that was too soon. Too soon.
Yeah, no, that was a little too blatant. But he also has made a lot of noise about the independent state legislature theory, which he seems to be like, well, maybe not right now, but maybe eventually we'll make it so that state legislators can, co-opt the vote if they don't like how their constituents have elected the president.
Can I take a step back right now and just do a meta commentary on our commentary here? People listening, if you're a listener, you're probably already kind of a law and court's head. But if you're not, if you're here because you love Liz's Trump stuff and like you're in it, Trump's your entree into this world. The way we're talking about these people is the way we all should be talking about these people. We talk about our presidents, and maybe if we're super turned on, we talk about our Congress. But we need to understand that the courts and our judges are our main policymaking and breaking personalities and politicians and institutions. And that we should understand these people as well as we talk about Schumer and McConnell and Manchin and MTG and Trump and Biden. AOC. Like, those people are, they're doing stuff, but their stuff's going to get vetoed or ratified by these, the empire. You have the empire and you have the Jedi pretty much on the court. And they're in this battle for democracy, in this battle for democratic values, to the extent those might clash with majority will.
Yeah, I think in this scenario, Chief Justice Roberts is definitely Yoda. He definitely thinks he's like the Yoda.
But no, like he's like,
no, he's not.
No.
Right. And that's the point. I think you're making an excellent point. These are human beings that have specific motivations. And look, you and I went to law school. I mean, I'm a little bit older than you, but we grew up thinking, oh, yeah, it's just balls and strikes. And
I did not. Speak for yourself.
Yeah, well, maybe I was like a naive, baby law student. And I was like, no. They really do care about the law above everything else. This isn't a partisan project. This is kind of above that. And I think it was bullshit then, but it is definitely bullshit now.
Well, yeah. And I got my start as a legal journalist. Again, to your listeners, it might sound like I'm some flaming liberal here, but I'm actually not. I'm kind of agnostic on almost every policy issue.
That's it. Get off. Interview over.
But I am deeply offended by the anti-democratic element of this court. And that's been a Roberts Court project from the very beginning. That I find repugnant to the American way.
Right.
And to the extent that this court is just mirroring what, the muscular judicial activists of the heroic Warren Court liberal era that, still governed the public imagination when we were in law school, even though it was sort of in its dying days during mine. It only was lasting that long, again, by sheer accident of bad Republican vetting for their Supreme Court justices after 1969.
Right.
To the extent that vision of was like the law, no, it wasn't. That was also, again, muscular judicial supremacy. Just happened to be goring someone else's ox. But the difference between that court, which animated the conservative legal movement, Bork, Scalia, then Leo, and all the people that came from there, and what we're seeing now coming home to roost in the conservative activism we're seeing now, was its position towards democracy. Now you can talk about Roe not being anti-democratic, and there's a point there. Yes, it was. But if you talk about the reapportionment cases that established one person, one vote, if you talk about breaking the back of Southern apartheid with desegregation, those on the surface level were, but they're going against the popular will or they're meddling in states democratic affairs. No, they were creating democracy out of an authoritarian apartheid regime, and those were the cases that really got the conservative legal movement moving in the first place, or it was vindicating democratic values but weren't necessarily majoritarian in making space for religious dissenters and their children in schools when they didn't believe in saluting the flag, and making sure that Jehovah's Witnesses weren't going to get lynched after the court in the first place decided against them because they were deferring to democracy as well as democratic values. Now you can go. I'm riffing here, but ultimately we have a court that, in its raison d'etre, isn't just effectuating the conservative policy preferences of their movement, but messing with the fundamental structure of American democracy to achieve that in perpetuity. So if you look at Citizens United, if you look at Shelby County, if you look at all the cases that flowed from those, they've all been for the purpose. You can say Citizens United was for free speech, but there's a strong argument that it was, fine. But a prevailing interest is our democracy and not distorting our democracy. Mm-hmm. And then Shelby County, which invalidated the pre-clearance formula for Section 5 of the Voting Rights Act, that again distorted democracy. And then you look at the case where they say, we threw up our hands, we can't police extreme partisan gerrymandering. There's no formula. In fact, while lower courts found formulas and they were able to do it, and they said, state courts can find a formula. Even if the state courts can do it, you can too. federal courts. And that further distorts our democracy. And then they're also relying on Senate malapportionment, which we can't change without 2 constitutional amendments, to protect themselves against any democratic will that emerges from the more representative House of Representatives when it's not, again, gerrymandered to the hilt. And also uses that anti-democratic chamber of Congress in Senate to get Supreme Court justices on the Supreme Court, because those are the ones where you get almost all, if not all, of the 6 Republicans were voted on or were confirmed by a number of senators who received less of the minority of the popular vote, overall. In the overall, if you count all the overall votes for Democrats versus Republicans, even as Republicans had a majority.
Right, because so many of the votes to confirm Republicans came from senators from places like North Dakota,
yes, exactly.
where we don't keep any, look, it was just not a diss on North Dakota, but that's not where we keep the people in this country.
And then the last thing is the Electoral College, right? So you're pulling every anti-democratic lever to maintain your power, even if you get control through our constitutional process, you're either using the anti-democratic parts of our constitutional structure, and then through the anti-democratic institution of the Supreme Court, you're relying on decisions that further entrench that minoritarian will to ultimately reach this place where we are at right now, with a court whose activism for its policy preferences are further supported and entrenched by rulings that mess with our democracy itself. And you can go post Dobbs with this too. There's the paper by I think by Kate Shaw and Melissa Murray of the Strict Scrutiny podcast, talking about, okay, the Dobbs 5. You said we're returning this to the people now. Abortion is for the people to decide. That's great, wonderful. But let's look at the states where abortion is now being decided, and what's happening with their state Supreme Courts, or what's happening with their state legislatures. What's happening with what they're doing as they're trying to get ballot measures for plebiscites? Are they, now there's a 60% threshold to put something on the ballot instead of 50%? You're trying for that? Well, luckily that got voted down because, women and other folk are not without their political and electoral power. Or Wisconsin, before they elected Janet Prosowitz, or however you pronounce her last name, as the fourth Democrat and therefore majority on the court. That was a rigged state.
Look, I mean, we saw it in Florida last week, where the state AG, Ashley Moody, argued at the Supreme Court to not allow a referendum on abortion and on legalized marijuana. These are things which people want, and they will do any anti-democratic thing to make sure that the people don't get to express their wishes.
Yeah. So, if we want to have a post-Dobbs moment that is truly about democracy and democratic will, which frankly was the talking point for Scalia all the way up on through, and it was what prevailed in the Dobbs opinion too, which is this is a matter for the people. Then you have to let the people vote, and you have to let them be represented in a way that reflects majority will. You have to. Otherwise, you're further rigging the system for your own preferences. And that, to me, to come full circle to what I was saying about my own policy is substantive preferences or agnostic. That's offensive when you're getting in the way of when you're saying go forth and do it, and then you're saying no, are you kidding me? We're still not getting your way. We're still going to reanimate a zombie statute from 18 whatever to
Comstock Act,
to institute a national abortion ban, even if we're not the ones declaring fetal personhood. There's all sorts of ways that the movement is now pushing in really offensive ways that should we survive 2024, or democracy survive 2024, will still persist. But we have to also survive 2024. And frankly, all this talk about courts, it won't matter if it's a long way in 2024.
Good Lord. I mean, we have to close this with you saying that democracy is over. My goodness.
Are you going to throw me off the podcast now? Because there's one more thing I want to talk about.
Okay. I mean, I'm not the one who has to go pick up my child.
I've got 10 minutes.
All right.
But the immunity case, the Trump immunity case.
Mm-hmm. That's in the election interference case, or actually, as Justice Merchan referred to it this week in his pleadings when he said, I'm not going to give you immunity. He referred to it as the federal insurrection case. And I was like, you know what? I'm going to go with that. Let's call it the federal insurrection case. I like it.
So in the federal insurrection case, as your listeners will probably know all too well, former President Trump is trying to delay his way out of accountability.
Mm-hmm.
And so far, it looks like he's been very successful. At the motion to dismiss stage, at his trial before Judge Chutkan in the D.C. District Court, he said, no, presidents are absolutely immune from any criminal act they might have performed while they're in office.
Right, unless they're convicted impeached by the House and then convicted by the Senate. And if you don't get, it was like ridiculous. And then some other bullshit about double jeopardy.
And Chutkan said, GTFO, right? Like, no, get out of here.
Right.
And then Jack Smith, knowing what Trump was up to, ran up to the Supreme Court while the case was also on appeal while Trump was on appeal to the DC Circuit. He said, justices, you got to get in on this now. You need to settle this because what's happening is a delay tactic. We can all see it. It's BS. Get this going. That was the end of December. Mm-hmm. And the justice said, no, regular order.
Right. They said, we'll wait on the DC Circuit to decide.
Mind you, they'd spent the Trump years ignoring regular order and shadow docketing the crap out of things. But because there was such a clamor against the shadow docket, they actually started blinking against the shadow docket when Biden came to power, which you can say is either cynical or principled and responsive to public outcry.
Right, just like Justice Gorsuch last week saying, I don't really like all these nationwide injunctions. Like, oh, now you don't like all these nationwide injunctions?
Right.
You're suddenly bothered.
Right, yeah. Luckily, he's now looking more principled on that. And I think he's sticking to his guns and he's not going to switch back, which is a good thing.
Oh, sure. Uh-huh.
And on that note, I fully agree. He's now dyed in the wool on this, I think. But just like Justice Barrett is now dyed in the wool against the shadow docket. Like she got spooked, and she's now whatever. You can say it's also fine. You're rolling your eyes. Everyone else, you can't see it, but she's rolling her eyes. This is neither here nor there, though. That doesn't matter.
Right. Sorry, I distracted you from your point.
No, I can distract myself from my points as your listeners.
All right, but let's get back to immunity.
Yes. So the DC went to the DC Circuit. The DC Circuit had already expedited it, so that might have been why the Supreme Court let it go. Maybe they said, okay, fine.
Or maybe just general cussedness. Could be that one.
Yeah. And the DC Circuit, they heard argument, and they took a little longer than people were expecting to come out with, but they did come out in due time, in good time, with a unanimous GTFO 50-page opinion, just making Trump look stupid. And it was joined by the most conservative, probably the rankest partisan of the active judges on the DC Circuit. And she didn't get in the way of this, Judge Henderson.
Yeah, no, I'm not seeing your math there. I think that there are some more. I mean, this is the DC Circuit has Justin Walker on it, and it has Naomi Rao. Yeah.
Well, so again, we can get into it with Walker on other things because he was less ranked partisan in the J6 obstruction cases as Katsas was, and as Henderson actually has been. But Henderson is also she's not a Second Amendment.
She's like 112 years old.
Yeah. But either way, Henderson joined the majority, which was two Biden judges and like a George H.W. Bush appointed. So far, that's counting 4 judges. All of them have said GTFO to Trump. Of course, 3 were Democrat, but 1 was a very strong Republican. And now it gets to the court. And they also said you have a week to get to the court. We're not going to sit on this. Like, you can't delay any more Trump.
Right. They said, right. The D.C. Circuit said, we're going to send this back unless you get a stay from the Supreme Court because, we see what you're doing.
And the Supreme Court then sat on it for a few weeks instead of just saying, yeah, no, cert denied. That was good. You guys, D.C. Circuit handled it. And go to your trial. We've blown the March 4th start date of Chutkan's plan. She lifted that, but she can get started now. That's not what the Supreme Court did. They sat on it. And then a couple weeks later, they said, yeah, we'll take the case. No noted dissents, by the way. We don't know what's going on behind the scenes. But they said, we'll take the case. Maybe they thought this was this was such an important matter that they had to have the final word on it. But it's actually not. It's actually not.
It's not. There's so many Nixon precedents that say the president is not immune. It's ridiculous.
And you don't even need to go there. They can just say he's not immune from this. In this, they don't even have to have this big sweeping thing. And then they set the argument for the day after the last possible day of oral arguments this term. They usually end on the last Wednesday in April. Now they're having the last Thursday in April for this argument in this case. So between then and May 15th, that's pretty much the cutoff to get a trial started and then ended before Election Day. Between April 25th and May 15th, hopefully they'll come down with a decision. And we all know the decision. There's no question the decision is going to be against Trump.
Right. I think everybody, yeah.
I mean, it could even maybe be 9-0, but 7-2 more likely, maybe 6-3, but it's not going to be 5-4 or more for Trump. It's not.
Right. Trump's position, just to be clear, is so maximalist. His position is that the president, this was the SEAL Team 6, which Judge Pan cornered Trump's lawyer, John Sauer, and got him to admit within the first 5 minutes that the logical end of your argument is that the president could order SEAL Team 6 to assassinate his political rival. And unless he was, impeached by the House and convicted by the Senate, he couldn't be tried for it because, that was part of his official duties. So this is a dumb argument. Everybody knows how this is going to come out.
Yeah. And I think the justices might have taken the case because they want to draw a line. They want to say, yes, that pan hypo is crazy and ridiculous. But, Trump's actual actions, they do fall on the other side of the line, but just this much on the other side of the line. They want to maybe draw some distinction between, where I think they want to say, yes, there is a doctrine of presidential immunity from criminal, whatever. But, Trump went past it. Maybe that's what they want to do. But if they start getting into all these things, they're going to blow that May 15th deadline.
I do not think that there's going to be, I think it'll be like the last one to come out. I think it's going to come out in July.
And if they do that, then justice delayed is democracy destroyed. Simple as that. Because then what's going to happen is American voters are going to go to the polls, and there's surprisingly a lot of them that are still wishy-washy about whether they're going to go back to Trump or go to Trump, that are saying that a criminal conviction will be dispositive to their vote. Maybe they'll get that in the Alvin Bragg in the hush money case in New York.
I think they will, yeah. But that's kind of a pissant case,
right? But this one is where people's eyes are. And, the Judge Cannon, she's going to delay her crap until unless the 11th Circuit steps in and removes her from the case, which they very well might coming up soon. Who knows? But this is the case, man. This is the one where if there's no conviction and the electorate goes to vote and they're not convinced that Trump's a criminal, despite, good on them for innocent until proven guilty. But, they're not convinced and they go for Trump and Trump somehow wins the Electoral College. What's going to happen then? He can be convicted and still after he's elected. Maybe
he won't, though, because the trial's not going to happen. Look, he's going to blow this thing up. He's going to pardon himself. He's going to get the Justice Department to investigate Jack Smith.
Yes, but there's a lame duck period between Election Day and January 20th. Yeah. Right? So what's going to happen between then? Who knows? But yes, he'll ultimately pardon himself, and the Supreme Court might then say you can't do that. But he's going to say, I don't give a damn what you say, Supreme Court, because you don't matter anymore because I am now a despot.
Right.
And so this is the fear. This is the concern that without that criminal conviction prior to Election Day, and this isn't a politically motivated. This isn't let's lock them up before Election Day because this is voters getting full information on what's going on. There's been plenty of time. The reason we haven't even gotten to a trial yet and isn't in full swing, wasn't started a month ago from the day of this taping, is because Trump has been doing delay tactics that everyone's rolled their eyes at, except for now the Supreme Court, which has said, yeah, we'll take it seriously. Mm-hmm. And that's a problem. Justice can't wait.
All right. You have now ended this show on a very somber note, but I would love you to come back again. Will you come back again and talk to us soon?
Always, of course. There's so much more to talk about.
Okay. Thank you very much, Mike Sachs.
All right, Liz.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.